Good afternoon, everyone. I'm going to assume you're out there. This is a little disconcerting because I can't see you. My name's Dan Headley. I'm a partner in our commercial team, and I'm joined today by my colleague Rob Coleridge from our commercial disputes team. Following on from last week's webinar about safeguarding your contracts in the era of COVID-19, today we're going to take a slightly deeper dive into how you might be able to change those contracts, how you might be able to vary them, or how you might be able to get some relief from your obligations under them. A few general housekeeping points first, if I can get the slides to advance. At the moment, I think you're probably just looking at our lovely mugs. Ah, no, good, there we are. If you hover your mouse over the presentation screen, you should see down at the bottom a little icon with some speech bubbles and a question mark in it. We'll save questions for the end, but you can submit questions anytime just by clicking on that box, which brings up the Q&A bar on the right-hand side of the screen, and type your question in there, and then we'll be able to see it, and we will get to them at the end. We're expecting to talk for about 30 to 45 minutes and then use 15 to 20 minutes at the end to answer any questions that come up. If you have anything that occurs to you after the webinar, you can always email us at events@owenmitchell.com, or just contact either Rob or me. All of our contact details are on our website. Now, since you're all at home, I assume you know where the bathroom is, and we're not expecting any fire alarms today. So if you hear sirens or screaming, then either your children are playing Fortnite or your house is haunted, and I can't help you with either of those. But we'll crack straight on. So without further ado, I will hand over to Rob to talk about varying and terminating contracts.
Thanks, Dan. It's good to be back. Yet again, I'm not, I'm afraid, in a misty mountain valley, but I am again at home in our spare room, as I expect many of you are too. Just to cover the topics we're going to cover today, I'm firstly going to cover some things about the variation and termination of contracts, some of which will be a reminder of things we dealt with last week, but as Dan said, we're going to go into that in some more detail. We're going to look at frustration again in more detail, and force majeure, since we've had a lot of inquiries about this, and we obviously recognise that it's a very important issue at the moment. And Dan's then going to talk more about the retention of deposits and considerations for consumer contracts, which are equally relevant in these difficult days. So moving into a brief reminder about the contracts we're looking at for the purposes of these this presentation, and generally, as we talked last week, the contracts which any business is dealing with are likely not to be those written down in a document in a carefully written form. Contracts can be formed in many different ways, and all of these contracts can be varied, but the important consideration that these contracts can come from different forms, as long as they all fulfill the key 4 legal criteria, which that being the offer and acceptance by the relevant parties of entering into a contract, an exchange of consideration, that being the agreement by one party, for example, to pay, that being consideration for services provided, that being the other consideration to the other party. Thirdly, an intention to create legal relations. The courts, the law generally doesn't recognise light informal arrangements such as car sharing agreements. There has to be that intention to create a legal relationship as a result of this exchange of consideration and offer and acceptance. And lastly, there has to be certainty of terms. That doesn't mean there have to be many terms, but what terms there are, such as payment, such as services, does have to be sufficiently certain for them to be identifiable. Given those 4 criteria, contracts can arise in a wide variety of situations, as you can see on screen. Simple informal dealings, such as business conversations, exchanges of emails, are often means of agreeing contracts, even where there is no formal written document. Also, courses of dealing, where parties regularly deal with each other, and what they do for each other, and the obligations they undertake to perform. You can find that contract situations arise, and that course of dealing is also worth bearing in mind that contracts can actually arise in situations where, in the course of the negotiation of a contract, so for example, where parties are negotiating a detailed contract and they start to perform their obligations well before the terms of the contract are actually agreed, you may find that course of dealing actually gives rise to a contract coming into place well before the parties intended to do so. And lastly, as most people will be familiar with, it's agreeing to contract on party standard terms and conditions. That situation is relatively simple, where you're relying on just one party's terms and conditions. But difficulties can arise, of course, where both parties have standard terms and conditions. And therefore you find your situation in a typical battle of the form situations, and you have to work out which of the last terms and conditions that were in place or sent through prior to the acceptance of the contract. Can take a difficult bit of analysis there and lead to some confusion. But whatever the contract is in place, there are various different ways, and usually ways of varying those terms, which in these difficult days is more prevalent than ever, because while parties are under stress, there's a lot of understanding at the moment that business relationships change, circumstances change, and so it's time and opportunity to refresh a contractual relationship and change obligations, change liabilities, so that they're better suited to these different times, and there's at least a little bit more certainty about where we are. So moving on to the topic of variation, there are essentially a number of different ways in which a contract can be varied, but generally the most common way for contracts to be varied is by agreement, and that variation by agreement is, in short, on the basic same terms that any contract is actually entered into, whether a variation is offered by one party and accepted by the other, and that variation is offered as part of an proposed exchange of consideration. Now, when it comes to variation, the exchange of consideration can be construed relatively narrow. If the benefit of a variation is beneficial to both parties, that can be sufficient for it to be an exchange of consideration. So that particular end is narrowed. But there also needs to be an intention to create legal relations, i.e. the intention that that variation will be binding and affect the contract. Even if that intention is narrow and to be construed by the conduct of the parties, that has to be there. And lastly, certainty of terms. Whatever or however the contract is varied, the terms of that variation needs to be as certain as possible. So when contracts are being varied, it's important to think about how you do that. Are there any requisite conditions that you need to think about? On screen, you can see we put authority. Where contracts can be varied, you may find that there is a provision within a contract that allows contracts only to be varied, firstly, if it's in writing, and secondly, or alternatively, if that variation has been approved by a person of certain authority, such as a statutory director, or even as a named person within the contract. Make sure you're aware of those clauses. Form, going back, again, this may be, any variation may need to be in this form specified by the contract. There may be some form of precedent which provides for contract variations, or it may simply need to be in writing. If there is a specific provision with the contract specifying how it has to be varied, then that has to be followed. In the alternative to a written variation clause, there may simply be a clause in the contract saying there may be no oral variation. If there's no oral variation, then variations may come into effect as a result of exchange of agreements in email. That is in writing and can be construed as such. The last point to consider when you're varying a contract is obviously commencement. And this comes back to the course of dealings point, which I raised earlier, in the sense that if you start adjusting your contractual obligations, perhaps potentially in the midst of negotiations, you may find that a variation has come into play earlier than you intended it, which could cause problems down the line. So if you are negotiating any form of contract variation, firstly, be careful in all of your correspondence to specify that those variations are subject to contract, i.e. subject to a formal document or a formal agreement of that variation, and agree a date on which that variation is to come into play so that there's no confusion down the line. The last point is really to consider is unilateral contracts, which are often included as part of some form of contractual mechanisms. It's not normally possible for any party to unilaterally vary a contract, but in certain circumstances, it can be provided for. And you will probably be aware that it's often seen in, for example, bank terms and conditions, as we often receive letters from our bank specifying the terms and conditions. And as a result, and that is a classic example of where a unilateral variation allowance is essentially only used in reasonable circumstances. And such clauses can be struck out by the court where they are, in essence, unfair. They give one party a widespread ability to vary a contract, but such clauses are rare. So moving on to termination itself. The first point, there are a number of different forms of termination. I'm going to go through each of these, and the first of these is termination by agreement. And this, to all intents and purposes, is the easiest to explain in the sense that termination by agreement is, in essence, a variation to the contract, where a contract comes to an end or is terminated by the agreement of the parties earlier than it otherwise would. That is simply the parties varying the terms of the agreement, and therefore all that I've just been through in terms of thinking about how to vary a contract apply equally when you are trying to terminate the contract by agreement. But there are a couple of additional things which you need to bear in mind. The first would be considering the practicalities, and the practicalities of actually winding up the operation you are seeking to terminate. Dan, if you could just click on a second there. And then when I'm talking about there, we're talking about what are what property or what obligations do the parties have when they are actually operating the contract. We're thinking about things like perhaps any intellectual property, which may be in use as part of the contract, any real estate that may be used by both parties, any customers that are serviced by both parties, for example. How are those issues going to be dealt with as the parties seek to wind up the contract? That needs to be considered as part of any negotiations and any decision to end a contract. Formalities. This is more to do with the legal relationship that endures following the termination. In many situations, you may find that breaches of contract or liability issues arise after a contract has been terminated. For example, if there is a partnership agreement between parties to provide services to third parties, you may find a situation where those third parties have a problem with those services after the contract itself or partnership has been terminated. In that situation, there needs to be a decision as to how those situations, how those complaints, how any potential claims are dealt with by both parties. Who has liability for those claims? How is that decided? And if there is any dispute about this, how are those disputes going to be resolved? These are all legal formalities that need to be considered, but can actually be dealt with in any form of a termination agreement. And it's worth probably thinking about it, and if they don't exist already, to document them and include them as variations into the contract before it's brought to an end. So moving on to termination in accordance with the contract. There are typically typical contracts that are well drafted these days will include clauses where a contract may automatically be terminated unilaterally by one party in the event of an insolvent event. You may be very familiar with these types of events, and it often occurs on an event of insolvency, such as the appointment of administrations or the entering into any form of a CVA agreement, for example. However, they may be more onerous. For example, they may be in the event of a failure to make any specific payment. There may be or a material change in the financial circumstances of one particular party. That's a common point to see, particularly in terms of banking contracts. Another point at which contracts may come to an end is obviously the inflection of time. If a contract is set to run for a specific period of time, then at the end of that time, the contract will come to an end. That does not mean, however, that a new contract won't automatically arise. If the parties consider to continue their relationship, their business relationship, after the termination of that contract, the old contract will still come to an end, but a new contract will come into place, and therefore the terms of that contract will need to be considered carefully. Is that contract going to be on the same terms? If no one does anything about it, the answer is probably yes. But what will be the termination of that? What will be the period of that contract? What will be the termination provisions of that contract? It all needs to be considered. Force majeure is another event which may bring rights to the end of the contract. Dan will consider that more in a minute, because what I really want to talk a little bit more about is the breach of contract. We talked a bit about this earlier on our earlier webinar, rather. We talked about, firstly, positions in contract where they actually provide for a position where one party may unilaterally terminate the contract in the event of a breach, which breaches are usually described as material breaches. They don't have to be described as material breaches. In some situations, you may find that one party is entitled to terminate in the event of any breach, but most negotiated contracts will provide some right for the party to terminate in a material breach. Now, material breach, it really depends on the wording of the contract itself, and we're talking about the natural and ordinary meaning of the words as to how they're expressed in the contract, rather than any wider construction than that. But what we can say is that where there is no construction or definition of what a material breach may be, the court would say it essentially is a breach which kind of goes to the core of the contract, or a persistent number of breaches which essentially affect the contract as a whole. And in that situation, it will give the party a right to terminate. It's worth bearing in mind that such clauses also regularly contain clauses requiring some form of notice, either to terminate the contract or to give the alternative party the opportunity to remedy that breach prior to a termination right arising. So it's important to pay close attention to the wording of those clauses. As I previously mentioned, if you are seeking to insert clauses along these lines into any variations, we would always advise that you refer specifically to the obligations which are at the core of the contract, so that both parties are crystal clear as to what where the key terms are for the purpose of termination. It is also worth pointing out that just because a breach of an obligation doesn't give right to a termination right, it doesn't mean it's not a breach of contract, and it doesn't mean that it doesn't give the other party an opportunity to seek damages for that breach of contract. Moving on to repudiatory breach. This is a more severe but difficult form of terminating the contract, and is a right which exists for any contract, whether or not there's a provision for material breach within the contract itself or not. Now, repudiatory breach can apply to any term of the contract, and it's important to bear in mind there that it may not just be the terms within the contract. If the contract can be construed not only from written terms, but potentially from a court of conduct or from the exchange of emails, i.e. the terms are spread across a wide variety of medium, and any breach can potentially be a repudiatory breach. But the important thing is that the breach is so severe that essentially it indicates to a reasonable person that the contract breaker has shown an intention to abandon and altogether refuse to perform the contract. Now, in saying that, I'm quoting directly from a recent case, and it gives you the impression that these breaches are very severe. It really just has show an intention not to perform. Now, in showing an intention not to perform, of course, we're talking about the time of performance of a particular obligation, which is relevant to the non-performance, or it can be anticipatory. If a party says, in the future, I have no intention of performing this obligation, that can be sufficient for a party to rely on to terminate the contract on this basis. It's also worth bearing in mind that even where, as I said before, a contract contains a material breach, it may be both material and repudiatory. They're not exclusive to one another, they do overlap. So if a repudiatory breach does come to light, it gives the non-offending party an opportunity to terminate. But to terminate, they do have to accept that breach, and they have to do so quickly. If that breach is ignored, the right to terminate isn't executed automatically. It has to be executed expressly, and as I said, has to be done as fast as possible, really. If it's not accepted, and the contract can, in essence, continue, i.e. if the party is a repudiatory breach, and then 2 weeks later it seeks to correct that breach, and the innocent party doesn't terminate in the meantime, that right to terminate is lost. That doesn't mean that that a right to claim damages as a result of that breach is lost, but the right to terminate will be lost. So if you are in that situation as a result of COVID-19 or any other situation, my overall advice in this particular position is to move fast and act swiftly, and as always, do seek advice if you need it. The last point I'm going to talk about is frustration, which is a position where a contract comes to an end in a situation which is, as you can see on the screen there, is totally unforeseen and outside the party's control. As you can see from the quote there, the key point here is the contract has to become impossible to perform. And this comes down to the key party's obligations. We're not talking, and by way of example, and using COVID-19, a lot of inquiries we're getting at revolves around payment obligations. Now, payment obligations are an interesting point in frustration because, of course, in the COVID-19 situation, payment is not frustrated. The obligations which would be frustrated would be, for example, a caterer having an obligation to or agreeing to provide catering services to a particular house or establishment, and they can't do so because of the restrictions. That event is impossible to perform because it would be illegal. However, in another situation where, for example, one party is obliged to pay for a service, potentially because they're due to pay for advertising or something like that, even where the market as that advertising has fallen away, the payment obligation itself won't be frustrated, and therefore that is not a frustration situation. One of the points to think about frustration, in addition to that, is that if the parties have in any way considered frustrating events as part of any contractual negotiations, to the extent that they may have included a force majeure clause, for example, here, then frustration is not going to be an application on offer as a means of terminating and bringing the contract to an end. It will show the party, the point there being that if the parties have considered it, it then comes off the table down the line. So if there is a force majeure clause in a contract, frustration is not going to be an available remedy. If, however, it is possible to frustrate a contract, then there is a situation, the default position essentially, that contract will come to an end and any monies paid will by default be repaid. There are exceptions to this. Under the Law Reform of Frustrated Contracts Act 1943, an old legislation, but which is still applicable. If a contract is frustrated, but one party, the payor, has already paid money to a payee, and that payee has incurred costs in the performance of that contract, then that payee can still retain monies in consideration for the expenses incurred in performance of the contract. Similarly, if a contract has started to be performed, but the payor hasn't paid money, the payee can seek compensation for any costs he's incurred. He can't, however, seek full payment for monies due under the contract. It is simply to cover him for the expenses he has incurred. So I think that pretty much covers what I was going to say about frustration, how to bring a contract to an end, how a contract may come to an end. And I'll hand over now to Dan to talk more about force majeure and a few other events.
Thanks, Rob. And if I can get the slides to behave. Yes, I can. Good. So it falls to me to talk about force majeure, which is something that is traditionally or typically looked at as almost part of the boilerplate of contract, something that is pretty much a copy and paste standard form and you don't really care about because there are more important things to be concerned with. And it takes something like COVID-19 to show that that isn't really true at all. It's one of those things that doesn't matter until suddenly it matters very much. And that's where we now find ourselves. Now, the key to understanding force majeure is to remember that, as its name suggests, it has its roots in the French Civil Code, and English contract lawyers essentially nicked the idea and implemented it in English contracts using, common law freedom of contract. What that means is that it's not something that actually has any existence per se in English law. English law doesn't know what force majeure is. There is no standalone doctrine of force majeure. It only exists insofar as we create it in a contract. And that's the key to understanding how this works. Everything depends on what the contract actually says. The phrase force majeure is not a term of art either, which for any non-lawyers listening in means it's not a word or a phrase that has a specific legal meaning. Again, it means only what we say in our contracts that it means. And it has some similarities with common law frustration that Rob was talking about just now, but it also has some very key differences. And the biggest key difference is that I suppose there are two really. One is that it doesn't necessarily require the contract to be completely impossible to perform at all. But perhaps most importantly is that unlike frustration, a frustrated contract will always come to an end. A force majeure regime will typically try to keep the contract alive, at least for a period. So it may temporarily suspend performance until whatever it is that is preventing or hindering it has gone away or changed. When you're looking at force majeure in a contract, you may also find that there are other similar concepts to be found in the contract, and what those might be depends rather on what sort of a contract it is. In my own field of outsourcing and IT contracts and project agreements and that sort of thing, you will typically have what is essentially a services agreement with a fairly clearly and objectively defined and measurable set of service levels or KPIs. And typically built into that regime, you'll have what's sometimes known as a relief event and sometimes known as an excuse event. And those are a sort of superset of force majeure, for want of a better way of describing it. They will certainly encompass force majeure events, but they will probably also include other things as well, such as particular milestones being reached in a project, or the customer failing to deliver certain dependencies, or whatever. Likewise, particularly in finance contracts like banking facility agreements, you'll often find a concept of a MAC, or a material adverse change. And again, that is something happening which is not a party's fault, but which has a bearing on its commercial rationale for the contract. So it's not necessarily stopping performance, but it perhaps removes part of the reasoning for doing it. The most typical example would be in a banking facility where you have a change in the borrower's financial circumstances, which causes the bank to rethink its lending risk. The other thing to bear in mind is that you might not have anything that's clearly signposted as a force majeure clause, and particularly in American agreements, where for some reason, I have never fully understood why, because I'm a simple man, but for some reason American lawyers like to have clauses that are a page and a half long and deal with 17 different types of obligation. And so you will often find buried away in a clause called general or miscellaneous a couple of sentences creating what is essentially force majeure. Similarly, in consumer contracts, because you can't use legalese in consumer contracts, you will often find them called something else. I did one once where we ended up calling the clause "stuff happens," which sounds silly, but it kind of gets the point across. Anyway, let's assume we've got a force majeure clause. What does that actually look like? How do we approach trying to rely on it? What does it do? Well, a reasonably well-drafted force majeure clause, and there are some shockingly badly drafted ones out there as well, but a reasonably well-drafted one will kind of have 4 or 5 different elements to it. And the first is the events or circumstances which will be considered force majeure, which will be the deus ex machina, the extraordinary external event, which has some sort of impact on the contract. And there are a couple of ways that those get drafted. There's the traditional way where you have the very lengthy list of acts of God: fire, flood, industrial action, lightning strikes. And those are notable mostly for being where lawyers leave little in-jokes for each other when they get bored. So you will find buried in those lists, I found alien invasion, zombie apocalypse. On one memorable occasion, Nicolas Cage was considered a force majeure event. Just his very existence, I don't know why, but there we go. Some poor lawyer somewhere was bored and stuck that in for a giggle. The other type will be much, much shorter and will simply say an event beyond the affected party's control or something to that effect. And that's perhaps one of the points of negotiation that generally arise in force majeure clauses at the time, because if you're a supplier, you want to keep the range of available force majeure events as broad and as general as possible, because you don't know what's going to happen. Generally, if you're a customer, you want to give your supplier as little wiggle room as possible. So you might go for a much narrower or perhaps even an exhaustive list of events. But either way, we have either some event beyond the reasonable control of the affected party, or we have one of a specified list of events. And that, in order to trigger the clause, will then have to have some kind of effect on a party's ability to perform. And this is where the devil is in force majeure clauses. And this is where a lot of people have been tripping up, certainly in the early days of lockdown, because an awful lot of force majeure clauses are written on the basis that the event or circumstance has to prevent performance. In other words, not just make it more difficult, but make it impossible. If it is possible to perform it, the contract doesn't, I'm sorry, it's been a long day. If it's possible to perform it, then the force majeure clause is not engaged. Other clauses will say something a bit broader. They might say prevent or hinder or delay. And there's a slew of case law about that kind of language, mostly from the shipping cases. But the upshot of it is that that works. So as long as there is some, appreciable adverse effect on the party's ability to perform, short of impossibility, that should be enough to engage the clause. But that is really the pinch point. If the force majeure clause is drafted so that it only applies if performance is prevented, then performance which is just more difficult or more expensive isn't going to cut it. That's not going to enable you to rely on the clause. I have sometimes seen force majeure clauses where commercial non-viability is actually enough to trigger the clause, so it becomes too expensive for the supplier to continue delivering the services. And that's very helpful if you want to rely on it, because that's more or less precisely where we are in many cases now. But it's rare, and it's really hard to negotiate it in. Typically you'll only get away with it in, for example, I think where I've most seen it is in small parcel carriage, where you're dealing in high volume, low margin, and really anything that goes wrong can, be it, increasing fuel costs or whatever, can render the whole contract essentially impossible for the vendor to perform. So in those circumstances, you might find it, but it's not the rule. Okay, so let's say one of the events has occurred and the effect that it has on us is enough to trigger the clause. But the next question is, are there any conditions attached to the clause applying? And it's very common to see, for example, a duty to mitigate or try to work around, and certainly in larger scale or longer term or more complex contracts, a duty to continue performing any obligations that aren't affected by the force majeure clause, or by the force majeure event rather. Related to that, are there any formalities? For example, it's very common that the party seeking to rely on a force majeure clause will have to give contractual notice, typically within a defined period of the event arising. And as with all contractual requirements to give notice in a specified way, the courts will generally construe those very, very literally. So you have to be absolutely clear on what the formalities are and make sure you stick to them to the letter if you want to rely on a force majeure clause. But let's say we've done all of that. Okay, the clause is engaged. We're meeting any conditions to its application and we've complied with the formalities. We've given notice in the prescribed way. What does that mean? Well, generally, it will say that we're relieved from our affected obligations for the duration of the event or circumstance. It might do other things, though. Unlike frustration, where you can generally get your money back subject to the point around incurred costs that Rob was talking about, if you're the party who isn't relying on the FM event, you're not necessarily going to be relieved from any corresponding payment obligation, unless the clause says so expressly. Also, there might be a right to terminate either for the other party or for both parties, but it doesn't arise automatically unless the contract says so explicitly. Remember, if you're relying on a force majeure clause, you are ipso facto not in breach of contract because you're relieved from your obligation. So there's no question of being able to terminate under the terms of the contract for material breach. But if the force majeure event drags on forever, are you stuck? Well, unless the contract says otherwise, probably. Is that going to move on? Yes, it is. All right. Oh, one other thing I should say. It is often the case that you will find certain obligations are carved out of force majeure clauses. It's common for payment obligations in particular to be carved out such that it simply doesn't apply to them. You will also find, particularly in outsourcings in regulated industries like financial services or law, that compliance with the demands of a regulator are not subject to force majeure. Anyway, but let's assume we've got a clause and it applies on its face and your counterparty is relying on it. Can it be challenged? Well, if construed correctly, it applies. Your options are going to be quite limited. As far as we can see, there might be an argument under Section 3 of UCTA, which I'm sure you're all familiar with, but for the record, it's a question. It's an ability sometimes to be able to disapply a term excluding the other party's liability for non-performance in their standard terms, which haven't been negotiated, if you can show it's not reasonable, that the clause isn't reasonable. And then, we're all familiar with the Schedule 2 factors taken into account. More interestingly, and perhaps more acutely at the moment, in consumer contracts, we have the Consumer Rights Act and a whole slew of additional rules. And that brings me quite nicely, if I can make the slide move on, indeed it does, to consumer contracts. Now, when you're dealing with B2B, there are a few rules about things you can and can't put in contracts, and there are sometimes very specific laws about certain kinds of clauses that won't be enforceable, for example, in the fields of intellectual property or personal injury. But by and large, you're free to agree pretty much anything you want, and the law will assume that you're both grown-ups and you're big enough and ugly enough to look after yourself. That is emphatically not true when you're dealing with consumers. Consumer contracts have lots of very strict rules. And they used to be dotted around between about 8 different bits of legislation. They've now been mostly consolidated into the Consumer Rights Act 2015. And the basic position is that for a term of a contract to be enforceable against a consumer, it has to be fair, it has to be easy to understand, and it has to not appear on well, specifically it's Part 2 of Schedule 2 of the Act, which sets out what are called the blacklisted terms, the terms that are simply void against a consumer from the start, no question. Now, force majeure clauses and similar provisions excusing non-performance by a trader are what are called grey list clauses, which means that they could be unfair, but they might not be if the circumstances dictate so. The law on this is quite vague and quite nebulous, and a lot of what we know really comes from the CMA, who, since the OFT was wound up, has had responsibility for enforcing consumer law. But for example, a long delay in performance without the option of a refund is very likely to be unfair. And terms purporting to limit or exclude your liability to the consumer are almost certainly going to be unenforceable. It is very, very difficult, and in many cases impossible, to exclude or limit your liability against consumers. Now, this is a particularly thorny aspect of consumer law, and this really touches on the situation where people have paid in advance for something that now isn't deliverable or isn't going to be deliverable because of the pandemic. A good example might be a colleague of mine who has had to cancel his wedding, which is awful. And the trouble is that the wedding venues and the caterers and what have you are struggling for cash flow because they can't trade. And so they don't really want to give him his money back, and he would quite like to have his money back because he's now not getting a wedding. And this is being played out in various forms the length and breadth of the country. The CMA issued guidance on this a week ago. It was the 30th of April, I want to say. And their view is that the law is very clear that if the contract is not performed, then the consumer is entitled to a refund. And you can offer credits or vouchers or whatever instead, but a refund has to be an option, and you mustn't pressure the consumer into accepting a credit or a voucher instead. They have to be able to get their money back if they want it. If for ongoing contracts, for example, regular deliveries or whatever, if you can only perform part of it and they've paid in advance for the full thing, then you can give them a partial refund for the bit you can't do. Again, you could offer them a credit or more time on the end of the contract or whatever, but they are entitled to that partial refund if they want it. On the other hand, if the consumer cancels, and this is a bit fuzzy in the guidance, but it seems to be the CMA's view that if the consumer cancels for reasons unrelated to COVID, they've fallen out with their fiance, they don't want to get married anymore, then refunds will work as per the trader's normal T's and C's, as long as those T's and C's comply with consumer law in terms of the general rules on fairness and so on. Quite how that would play out, I'm not sure. I could see arguments getting into the reasons for cancelling. There are also specific industry sector rules. For example, in transport, there are various conditions of carriage and statutory regimes. Now, all of this is not law. This is the CMA's view of what the law is, which isn't necessarily correct. But to prove them wrong, you would have to fight them. You probably don't want to do that. So where that leaves us is a situation where an awful lot of businesses who are, dealing with consumers are probably going to have to give people their money back. And there probably isn't going to be a way to wriggle out of that. Now, that's pretty much all I have to say on that. We have up on the screen our events email address, and I think we have, yes, we do have time. Look at that, we're bang on the 45 minutes. Let me see if I can bring the Q&A box up, and we'll see if we can do some questions. And we've got some submitted in advance, which we will do first. Can we make Rob live as well, please?
Dan, I'm on now, so yep, I can certainly help with this.
Excellent. So I believe the first question is around the public procurement rules.
Yes, this is quite a specific question. The question is from Graham Reed, and he's asked whether, in relation to extending a current contract procured under the OJU, or which is the public contract regulations, and the limitations of Regulation 72, does the maximum financial increase 50% of the original contract value likely to change as a result of the coronavirus crisis? Just to explain the question, public contracts, to those that don't know, if they're over a certain value, they have to be procured by a public authority in line with the public contract regulations. There's certain requirements of fairness and transparency when they do that. And all this law stems from a basic European regulation. And one of the specific provisions of the regulations is that variations to contract can only be imposed by parties in certain circumstances. And this particular regulation, the 50% rise, he's referring to the point where there's a situation which is unforeseen by the public authority when it enters into a contract, and the increase or the contract price is less than 50% of the original, then I think one of the circumstances then the contract can be varied. This is, however, a statutory limitation on how these public contracts of this nature can actually be changed. And in the circumstances, I think these are circumstances where public authorities may want to change contracts, but I still think they're going to be bound by the 50% increase limitation. And if it is going to change, it will require parliamentary time to impose new legislation. Now, given the time that Parliament is taking to deal with the crisis at hand, my view is that this kind of change is not going to come in for a while. It's possible that the government may seek to change the legislation like this, so to increase that limitation so that the changes can be imposed to a greater extent. But I personally think that's not going to be for some time. It could now, the important point is it could now be changed as a result of Brexit. It could be very beyond that, because it was originally dependent on European legislation. As a result of Brexit, these can now be changed. So we may see this in the future, but for the time being, I'm afraid it is what it is. So we've also got a couple of questions on employment situations. I think Dan and I will kind of give you some answers there, but just bear in mind to anybody who puts questions about employee misuse, employment law in the situation is a very specific area of law. We've got an employment team dedicated to do that. So we will forward these on to the employment team just in case, but we've had a couple of queries. One of them is, can we insert a new term in contracts that requires employees to have broadband and the ability to work from home? Now, this goes back to contract variation, and whilst despite what I just said, if they're being special subjects, the simple issue is no, you can't. That is a unilateral change to a contract. So you could change the contract if your employee agrees to that. For example, you pay him more. If you pay for that broadband he has at home. But no, you can't require your employees to have broadband and the ability to work from home unilaterally. You can't impose that on them. The other question we've had is, do I need to get employees to sign another agreement to bring them back off furlough? My understanding is that when you enter into the furlough agreement to begin with, then ideally you should have provided for the circumstances in which the employee will be brought back. But essentially, when the furlough ends, they will automatically come back in on the same time as they were on previously. And there's no need to enter into another agreement. And lastly, how to ask employees to reduce their hours on a temporary basis in order for the business to save cash. Well, I'm afraid reducing employees' hours on a temporary basis, again, is a variation to the contract. And businesses can't impose that on employees in any circumstances unless they agree to it. This is happening a lot at the moment. Employees are agreeing to take temporary wage cuts or temporary hours cuts because of the financial pressure that a lot of us are feeling. But those impositions and variations are all on the basis of agreed variations to their contracts, and therefore it needs to be approached in a very negotiation style, and it needs to be stressed that if the employees don't accept a reduction in hours limits, then it won't affect their existing terms and conditions. If that is not the case, then there is a risk that an employee might have an argument for constructive dismissal or another potential related claim to that. So be careful in that circumstance.
I should add that employment contracts are something of a special case to which a considerable number of additional rules apply. And so, as Rob just touched on there, for example, a unilateral change to terms of employment could be seen as a constructive dismissal. So do not try to do such things without taking advice from an employment lawyer. At the risk of special pleading, our employment team, Employment Law Firm of the Year, have published an awful lot of guidance on the COVID Hub on our website on how the furlough scheme operates and how to approach it and how to have these sorts of conversations with your employees. So I commend that to you, and if you need specific advice, do ask our employment team, because they are very well across it.
We've had another couple of questions coming in. Yeah,
yeah, we've got a couple of others come in. So let me see, what do we have? We've got one about managers taking a pay cut, which I think is again a unilateral change to terms of employment. So again, really a matter of employment law. In principle, could amount to a constructive dismissal. Other than
we've had,
that,
I've had one contract.
A question about a contract for venue hire. Do you want to take that one, Rob? And then I think
yeah, absolutely. So the question is, in relation to a contract of venue hire for an event, and the event is due to take place within a matter of weeks, and government guidance remains unclear on public gatherings. If the venue offers an alternative date in the future, will this negate a force majeure clause if they're trying to find a way to contract? Well, as Dan says, force majeure clauses will only be interpreted as they are written, and it will depend on how that force majeure clause is drafted and construed as to kind of what effect it will have. On the basis that, assuming that this is a consumer style contract, then if it is cancelled in any way, then you are in the realms of the Consumer Rights Act, and you have to look very carefully as to what refunds you are obliged to pay to your customers in that circumstances. But generally speaking, while government circumstances remain unclear, I guess the point is, if to all intents and purposes, it could be argued that it is legal to hold this event, then I think you may be in difficulty in terms of whether or not you can hold this. But it really does depend on the way. It should be said,
though, that I think there is a good argument that holding that sort of event is probably illegal.
As much as that, I agree. But
as of today,
yeah.
I think the more difficult question is, because of course venues are booked many months in advance. And perhaps the question is, if people are asking for, refunds for events booked in September, October time, when really we don't know what the world is going to look like, that perhaps might be a more difficult question. I think in terms of a venue hire for an event today, that event would be unlawful.
Yeah. Yeah, I can't. If it looks like it's in the future, and on that basis, I think you need to kind of, if there is an ability for you to stall making a decision, you should try, because the more guidance you can have in terms of the restrictions in place, the better position you'll be in. But it really is going to depend on the date of what decisions on the date of performance itself. And I recognise the difficulty this is placing you in, insofar as you may have to cancel now, not knowing what the position is going to be at the time for performance. And that is a very difficult position, and we need to go back to the wording of the contract. What I've been advising on a few of these situations recently, and I have been finding that this situation has been met very constructively by both parties, by all the parties in the circumstances. Particularly, obviously, in B2B contracts, B2C contracts, hard to determine the situation because there are such a wide range of consumers who may have contracted to attend form of events. But for B2B type contracts, I have found that both parties are willing to kind of sit down, discuss the situation, and agree how they're going to deal with it as the situation changes. And I would strongly recommend that wherever possible, parties try to resolve these difficulties between themselves as early as possible.
Good stuff. Okay, we have a question from Anonymous. COVID's clearly delayed many building contracts. Force majeure rules. Can contractors rely on this to extend the contract period, and would only time be affected? I'm assuming that means B2B construction, so not the domestic builder building an extension to your house. The answer is it depends what the force majeure clause says. Remember, force majeure has no existence outside the contract. So you can only rely on it if the clause in the contract allows you to rely on it, and only for the things that the clause in the contract allows you to rely upon. I think that's a reasonable summary, isn't it, Rob?
Yeah, no, I wouldn't add to that. That's spot on.
All right, and we have a question from Keith Donald. Question re variation of contracts. If a party doesn't comply with the variation clause and the other party accepts the variation, have both parties waived the terms of the variation clause, e.g. amendment of agreement by email when the clause says in writing with a specific form used and signed by named individuals such as head of procurement? Sorry, Rob, can I take this one because I love these?
Absolutely, go ahead.
There used to be a school of thought that said yes, that would be the case. I think that was comprehensively squashed by the Supreme Court. I can't remember if it was 2018 or 2019, but fairly recently, in a case called Rock Advertising, where Lord Sumption, who gave the lead judgment, said essentially that freedom of contract means the freedom to bind yourself in the future. So you can say, for all sorts of good and sound reasons, actually, we don't want to change this contract by accident, so we want to specify a very particular way of doing it, and that works. So following that decision, I think the answer to your question is no.
Yeah, I would agree with that entirely. Where the case is very clear about where the contract is type-specific way for the contract to be varied and it's not complied with the variation.
For the lawyers on this, if you haven't read the judgment in Rock Advertising, I strongly recommend you do it. It's very short and it's an absolute intellectual tour de force. Genuinely a brilliant read. Sorry, I'm a nerd. Okay, I think that is, we're coming up to the top of the hour and we seem to have run out of questions. So I think that is probably a good place for us to leave it. Thank you all very much for listening in. I hope it was useful. You can ping any questions, thoughts. We will be circulating a link to our feedback form, which we very much would like you to fill out. Obviously you don't have to, but it would be greatly appreciated. So it's thank you from me and thank you from Rob. And
thank you for me.
Have a great day, everybody.
Many thanks.